Okay. Senator Ben Shenton, you're here in your capacity as Chairman of Scrutiny Panel Chairman's Committee, which is rather a mouthful. We're a bit put out as we're a blogging group. We've been told, unlike Channel TV and the rest, that we're not allowed to video necessarily Scrutiny Panel meetings anymore. We were, but we're not now. What's the background behind this?
Well, it came up at the Chairman's Committee, the last meeting. Deputy Lewisier raised it because I believe you've been in contact with him. The agreement was initially just to give you 3 days notice, or if you gave us 3 days notice, we could then notify the witnesses that you wish to carry out the blog. I think where the problem we had was we have had situations in the past where witnesses have been recounting very, very personal aspects of their life, and there was one particular one that I remember where the witness actually broke down when talking about their problems with alcoholism within the family. It wasn't their own problems, it was problems with their mother. And so I think what we need to do is look at the human rights issues, not just the human rights issues for the witnesses, but also the human rights issues for you as bloggers. Was that on the agenda when you looked at this? Was human rights on? Did you look at any specific articles? Well, no, I'll be honest with you. When we actually raised it at the meeting, the mandate that we were looking at was quite narrow. We were looking purely at your case, looking at scrutiny meetings, and then people raised, what about the human rights issues of the witnesses? What's the difference between the bloggers and the media such as BBC and
So Channel. It was fairly specific to us, and
that's right.
It was fairly specific.
And then people asked, well, why aren't state sittings televised? When do you let cameras in? When don't you let cameras in? And the whole medium of blogging is quite new, I think, and so I think it's something that needs to go back to privilege and procedures, so that we can look at it as a complete issue, as opposed to one little
A whole
incident.
review is in place, but in the meantime, we're effectively barred. If the chairman doesn't like the look of our face, he'll say we can't video record a meeting or part of it. Obviously we wouldn't record a whole meeting or part of it, and we are sensible, we do have discretion, but effectively that is the rule, but it doesn't seem to have much legal basis to us.
It doesn't have legal basis as such. I mean, the rules that we have set down within the chamber, for example, no one's allowed to video state sittings. They're sort of in standing orders, and it's down to the Privilege and Procedures Committee. But I can see both sides of the argument. I can see why someone would not want to be videoed if they're recounting something personal, and I can see your point of view with regard to freedom of information and your right to access. So it's something we need to.
Well, especially since Channel TV or BBC, if they want to, they are allowed to video.
Yes, what they tend to do is just use it as like a shot with an overview, maybe because they don't get enough sound bites out of scrutiny.
Well, that's because they're very boring meetings generally.
Well, yes, that is the case, unfortunately.
So it's specifically about us. There's a rule in which may or may not be a rule. Are you going to maintain that rule? Are you going to say that does stand, that rule that you've made?
It's going to stand certainly until the next Chairman Committee's meeting, and until we get some feedback from Privilege.
Of course, we weren't invited to that. We couldn't present our views. You didn't think about inviting us to say our piece before you made the decision? Well,
it was quite late on the agenda. It was something that cropped up after the meeting with Roy's panel, which was the education panel. Some of the ministers have indicated, for example, if people are allowed to video, that they won't turn up. Well, they will turn up because they've got no choice, but they won't actually say anything. So we have to take this into account.
That's something that would be rather interesting to video, wouldn't it?
Well, I think the whole issue is going to be quite interesting.
A silent president refusing to cooperate just because a video person's there is rather uninteresting.
I think the problem is that a lot of people don't realise that blogs are here to stay. And I think the moment some people feel that blogs are an irritant that may eventually go away, but believe me, they're not going to go away. They're always going to be here, and we do have to change the way we communicate.
From a practical point of view, we don't get a mailing list. We don't know when the meetings are going to take place. There's no information. We can't comply with the rule, 3-day rule as you've invented. We can't physically comply with it. So
we have to make sure that you are fully aware of when we're going to have meetings. Certainly, meetings are. I mean, for PAC, for example, we know when the meetings are for the next 8 or 9 months. Most committees will know well in advance of when the meetings are, so certainly we can improve that aspect.
And if somebody objects to us, are we going to have the right to appeal against their objection?
Again, we're going to have to bring this up at the meeting.
But in the meantime, until you get that?
Until you get that, I'm afraid you're a little bit in limbo.
Are you quite sure you've got the legal basis to make that ruling? A discriminatory ruling allows one sort of media to say yes and one's not to do.
I'll have to check on that. It's a good point, but I'll have to check on that. We haven't taken legal advice.
Okay, thank you much indeed.